The scene out there and outside the courthouse, we have John Teakell. He is a former federal prosecutor, now in private defense practice in the Dallas area. And John, I just wonder, what's your sense of how well the prosecution is doing in making what is certainly an unusual case? That is, hey, so it was an accident, but her failure to get aid afterwards makes it murder.
Well, good morning. Thank you for having me. It is true that it is an unusual case in the sense that the evidence that the prosecution has is after the fact, and because of that, they're going to have to focus as much as they can on all the activities of the defendant and her hiding the body, and the fact that this person could have lived possibly and suffered in pain before the defendant took action to do anything, and apparently the only action she took was to try to help herself. So it is unusual in that sense, and it's going to be an uphill battle, in my opinion, for the prosecution to get a murder conviction. So therefore, they're going to have to focus as much as they can on the forensics and the fact that this person possibly could have been saved.
Let's ask Professor Schwartz here. Let's ask John Teakell. He practices law there in the Dallas area. John, what do you think of that?
Well, I think the professor is correct in the sense that it's an egregious case, and there's the risk that the jury, regardless of the evidence, may feel compelled to go ahead and find the defendant guilty of something, and to go ahead and check that guilty box on the verdict form. Now, I do believe, as I said earlier, it's still going to be a challenge for the prosecution to prove their felony murder as they've alleged. They've alleged kidnapping as the underlying felony, and so therefore it's important for them to bring forward evidence that the man was alive and could have been saved, as they're trying to do. Of course, we've heard from Cleet Jackson, and I suppose others who will say that he was dead, or who've already testified that he was dead just in a relatively short time period.
Okay, before we go back in, the testimony so far in this case raises a fundamental question that I want to bounce off John Teakell first out there. He practices law in that area, and then have anyone else who's with us on the air here to kick in if they have some thoughts about it. Mr. Teakell, here's what we've heard so far. Everyone involved in this case, in a criminal way or in trouble in this case, got that way because when they were first confronted with what had happened, they didn't say, well, what's the right thing to do? What's the legal thing to do? Chanté Mallard, when she hit this man, it was an accident. If she had said, what's the right thing to do, she would have saved his life, perhaps, and kept herself out of so much trouble. Her friend T, if she'd have said, hey, you got to go to the police, or I have to call the police. But T didn't do that. She lied to the police. And now the former boyfriend, who's on the stand now, he didn't have to get involved in this. If he'd said, hey, you got to do the right thing, the legal thing is to tell the police. He calls his cousin. The cousin doesn't say that. And everybody is in trouble. In your practice, John, is this an aberration we're seeing here? Or do people do incredibly stupid and illegal things because for some reason it's not part of their mental makeup to say, well, we got to do the right thing?
Well, no, it's not an aberration, and believe it or not, you'll find this throughout the criminal justice system and defendants in certain situations. These people were friends, acquaintances. Apparently Mr. Jackson had strong feelings for the defendant, and possibly the defendant and others did panic and want to protect her. We can't read their minds, but I'll note that the defense strategy is, as I believe Jeff Kearney mentioned on his opening statement, that this is simply a hit and run, and she panicked after that. Other people came in and took over, and they're basically responsible for what happened going forward. I'll point out further that I think it was a good strategic move on the part of the defense for the defendant to plead guilty to the second count, because they can go to the jury on this murder count with credibility, claiming, look, we've anteed up to what she's guilty of. It's after the fact, tampering with the evidence, but that's all.
Gene, you have any thoughts? John, would you put her on the stand?
Probably not. I would be very hesitant to put her on the stand. Again, the professor's correct in the sense that there's a risk that the jury may be so emotionally inflamed because of the facts and the photographs and all the evidence that came in. But I'd like to point out something else. In Texas, in state court practice, in the defense bar, there's something that's known as a slow plea, and that basically means that you know that the state has evidence to convict, but you're going to go to trial anyway because you can't take the offer that's been made by the state. So we're going to go in and probably going to get convicted, but we're going to ask for probation or a lenient sentence in front of the jury. Maybe that's the strategy of the defense. Jeff Kearney's a good attorney. I know him personally. He's very good, and he's good in front of the jury. But maybe that's kind of a fallback position as well as trying to say the state really cannot prove their felony murder.
Okay, now we're going to have to sit in there taking this hard fall. And John Teakell, what do you think about 10 years in this situation? And to use the wife, I mean, is that a kosher thing to do for the prosecutors?
I think so. It's 10 years is not out of line for this, for what he did. He's going to know that he's probably not going to do the full 10 in the state system anyway. But still, nonetheless, the fact that he's getting 10 years is going to be good for the prosecution because, as you mentioned earlier, going in with a plea agreement and someone who's going to testify, if they just got immunity or got probation or something like that, then they wouldn't come across as being credible for the prosecution. And so they can argue that this person got 10 years and therefore the defendant should be convicted. In regard to your question about the wife, sometimes you see that getting an additional perk or an additional pass on someone else, but not usually. It's probably only in a more high-profile type of case like this are you going to see something like that.
Okay, thank you very much. We're going to take a break here and then we'll return to our coverage after this.